Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. I'm here with Ann Lipton, as always, a law professor at Tulane in New Orleans, who teaches and researches securities and business law. She holds up the legal end of our podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Well, this week, Ann, I've been thinking hard a lot, eagerly, about this discussion, because we're going to continue to look at some of the legal changes, and changes is probably mild, that have come up in the past few weeks. Earlier, we looked at some new SEC rules that apply to shareholders of really big index funds, how they interact with portfolio companies. That was like nothing compared to what's going on in Delaware. And like I said, I've been waiting eagerly to have this discussion and get, to have your views about what's happening and explanation, because there's a lot going on. At its core, there was a legislation, a bill was introduced into the Delaware legislature earlier this month, and it has the potential to really shake up corporate governance and securities law and Delaware and all sorts of fun stuff. So,
the changes in Delaware, I think they represent this other dimension of what looks like a shift in power in general from to insiders from investors. So we'll talk about what got changed, and then you can tell us how that's likely to affect activism.
Right, and then we can have a fun discussion about what it means.
Yeah,
well, at least at this early stage, because it's only a couple weeks old.
We're talking about this quite a bit.
Right, but
this is only the big broad intro.
But there are some broad themes and some conclusions that we've started hinting at right here about for Delaware and corporate law generally. And power really between
that's exactly it.
Between companies, between investors, between minority investors and majority investors. There's a lot of power dynamic here.
That's exactly what this is. This is the theme for the moment. It's this power shift.
Right. Well, so let's ask. So what happened in Delaware? So let's lay the groundwork here.
Okay. So on February 17th, Delaware's legislature introduced this bill. That would make these really major changes to Delaware's corporate law. Now, the governor, Matt Meyer, he'd actually been telegraphing that the changes were in the wind for a while, but this was really a shock, partly because of how extensive the proposals turned out to be, but also because of the process. Normally, Delaware has this really specific process for amending its corporate law. First, the changes are
statute. For amending its statutes.
To amend the statutes. So the changes aren't actually usually proposed by the legislature. They're proposed by the Corporation Law Council of the Delaware State Bar Association. It's called the CLC. It's just a council of Delaware attorneys. They draft the changes, they vote on them within their little group, and then they pass those on to the legislature, which usually just enacts them as written. But this time, they completely bypassed the CLC. Instead, the changes were drafted by a small group of attorneys working, as I take it, with the governor and maybe some members of the legislature. And I think now that after they were introduced, they were finally passed on to the CLC to review. But I don't have a sense that the CLC really is going to make any changes, or it understands that it's not supposed to make changes. So the changes are pretty dramatic, but even how they were drafted is a huge departure from how Delaware usually operates.
And there's a couple things that I'm just aware of, though I don't follow the machinations of Delaware nearly as closely as you do. So this basically the Bar Association, through a deliberative process, normally. And they'll be consulting with, plaintiffs' attorneys and defense attorneys and all sorts of people.
I think it's defense heavy, but the group is it's a mixed group,
right?
And they normally draft these things sort of in this process together, and they just skip that.
And there's a good chance that they were as surprised as the rest of the world.
Oh, that's my understanding, that the CLC was very surprised by the changes as well. This just came out of nowhere. Although, for the most part, most of the defense side firms have fallen in line behind.
Right. Well, because as we're going to talk about, this is favors companies pretty well.
It favors insiders and managers. Whether it favors companies is
fine. Okay, great. And this, just for reference, this is Senate for people who are keeping score at home. This is Senate Bill 21.
Yeah, it's called
in
SB
in the Delaware legislature, the upper chamber. Yeah. All right, cool. And so, what's our understanding about why, not necessarily why, or maybe why the state both did it this way and why they wanted the changes that they're. I mean, is it because they're all the company because Tesla left and Meta's thinking about it and so forth?
Yeah,
or?
yeah. So this is definitely about these threats to leave. So we know Elon Musk has been complaining about Delaware ever since Chancellor McCormick rescinded his pay package.
Before.
That's on appeal, right? That's on appeal.
I mean, that goes back to Solar City. I mean,
yeah. Well, no, he won that one, but he was very upset about Twitter. But he started threatening to
Right.
leave when Chancellor McCormick rescinded his pay package basically a little over a year ago.
Right.
And that's on appeal currently. And now some of
the pay package one. The leaving
package,
leaving is done. That happened.
Yeah, he left. So he reincorporated, Tesla reincorporated to Texas. And now some of Musk's associates have threatened to also leave. So Mark Zuckerberg threatened to take Meta out of Delaware. Bill Ackman threatened to take Pershing Square out of Delaware. Drew Houston and Dropbox. Houston is also on Meta's board, so it's like one little click. And there are these rumors that a lot of companies are also warning that they plan to put reincorporation to a vote this proxy season, and that's, as you know, coming up in the next couple of months.
Right,
unless Delaware makes
imminent.
Changes. So
okay.
So Delaware is feeling that like if they don't make changes right away, then they're going to be reincorporation proposals all up and down the ballot in the next few months. So I should say that there are a lot of people, professors and plaintiffs' attorneys, who've amassed a lot of data suggesting that Delaware is doing just fine in terms of retaining incorporations, that these are just a couple of different outliers, that they don't really represent everybody. But they, the people collecting that data, they obviously can't see what's coming. They can't see whether these threats to reincorporate in the future are real. They can't tell whether VCs will start organizing outside of Delaware. They start their startups outside of Delaware in the future. So we'll just leave it at there's a dispute about whether these threats are serious, but there is no question that the Delaware legislature thinks they're serious.
Oh yeah, they're concerned. They're worried
really
that and again, whether or not those worries are well founded is for a different podcast. But okay. So and it's worth noting that of all the companies we've talked about, only one, the Musk companies, and I think it was Tesla and maybe one other, reincorporated so far. All the rest are just kind of speculating.
There have been a couple. There have been a couple of reincorporations. Tesla, obviously, the big one, but there have been a couple. But most of those, incidentally, were ones with controlled companies.
Right.
So where it's really not other than Tesla. So it's hard to say whether you could get a shareholder vote in support when it's not a controlled company. But
right. Well, okay, interesting. All right. So
if this affects the startup ecosystem, then it doesn't matter. So it's a mess. And Delaware is obviously very concerned.
So going beyond Musk's tantrums about this. This isn't just about Musk. What's the source of the aggravation here? What do we think's going on?
Essentially, they think that Delaware law is too strict when it comes to evaluating conflicted transactions, situations where members of the board or corporate officers or controlling stockholders may have a financial interest in a contract, so there's a risk of self-dealing. Like a board that consists of Elon Musk's friends deciding to give him $56 billion.
Yes, that was
like Oracle deciding to buy NetSuite, which is a company that Larry Ellison, Oracle's founder, had a large stake in. That kind of thing. So this is about these conflicted transactions. And we've talked before about how Delaware deals with conflict transactions. We've said this before, the standards. So for these kinds of transactions, normally, if a shareholder sues saying you paid too much because you wanted to please Larry Ellison, or if a shareholder of a Target sues saying you paid too little because you were interested in the acquirer, a court normally will examine that deal for entire fairness, which is this very searching evaluation of whether the deal used a fair process and achieved
and arrived at a fair price, right?
Exactly.
Right. Okay.
And so there's a trial, there's discovery, there's depositions, there's hearings, and there's a potential for a large damage award. And that's, it's a pain. It's a pain even if the defendants win in the end. That's still very expensive.
It's very, very processed. As good as the Delaware courts are.
They only bother with a rush if there's like a deal that's pending. If the deal's over, they'll take,
but it's
still
still
be faster than like a federal court will be, but it'll take time.
Right. And one aspect of their being good is it's really thorough.
Yeah. So the board, and this is pre-existing law, this is the law that essentially would change, the board can cleanse a deal, which essentially means that an independent decision maker approves it. And if they do that correctly, then the court will not evaluate the deal at all. If a shareholder files a lawsuit, it's going to get dismissed out of the gate. So the issue is, how do you cleanse it so you can avoid judicial review? Most of the time, if it's just a conflict with the board of directors or conflicts with a corporate officer, you can either cleanse at the board level or at a shareholder level, which means if an independent board votes in favor of it after receiving all material information, we're done. Or a committee. If an independent committee votes in favor after receiving all material information, it's cleansed, you can't sue. Alternatively, if the disinterested shareholders vote in favor after receiving all material information, we're done, you can't sue. Now, the standards
and that makes sense.
Yeah, right. It's the idea being that's
right. I mean, if shareholders want this to happen, and they're fully informed, which is one of the problems with Tesla's campus. So, and Tesla's want who's Chancellor McCormick or Vice Chancellor Lannister say, okay, you shareholders, exactly we're not trying to tell you what to do. We're just trying to make sure. Okay, you're right.
But it's different for a controlling shareholder.
Right.
And when it's a controlling shareholder, you need both mechanisms. You both need a committee of independent directors, and you need the disinterested shareholder vote. The disinterested shareholder vote isn't good enough because and the committee isn't enough because essentially the theory is the controlling shareholders sort of have a lurking threat that they could retaliate.
Oh, they could coerce people or something.
So under existing law, you need both mechanisms to cleanse deals that involve a controlling stockholder. But I want to make clear, though, I'm making it sound easier to challenge these controlling stockholder deals than it actually is. Because for many transactions, the claim would have to be brought derivatively rather than directly. And if it's brought derivatively and the company has an independent board, that claim is going to be dismissed anyway. We don't need to get into it unless you really want to. But just leave it at, if it's a derivative claim with an independent board, it's going to be dismissed. So even if there's no cleansing. So for the smaller transactions, as a practical matter, those are going to be insulated from challenge a lot of the time.
Okay.
But for the bigger transactions, the shareholders will get to this entire fairness review if the controller doesn't use both cleansing mechanisms, independent board and disinterested shareholder vote, or independent committee and disinterested shareholder vote.
All right. That's current law. That's current law. SB 21 is changing some of that, I think, right? Okay, what's going on?
Okay, well, first, I want to make a note that we are recording this on the morning of Monday, March 3rd, and the reason I want to make a note of this is because I don't know if something's going to change tomorrow or later today. So in case anyone's listening, this is how the changes were introduced as they exist coming out of the legislature.
Right.
So the first thing the bill tackles is independence. What does it mean for a board member to be independent so that they can engage in this cleansing process? Right. Under Delaware law, it means no financial interest in the transaction, and they don't have close ties to someone who does have an interest. So for a director to be independent, the director can't be a party to the transaction, and the director's mother can't be a party to the transaction, that kind of thing.
Yeah.
But in recent years, for that second question, is the director too close to someone who has a financial interest? Delaware has gotten very strict. Courts will look to longstanding business ties, longstanding social relationships. They'll really dig down into the texture of this relationship. Like I think we mentioned on a different podcast, my favorite one, where the court highlighted that the director vacationed on the ranch of the counterparty, and they castrated calves together.
Right, and that was deemed to be compromising of their independence from each other. Or we can look at the cases that I'm more involved in, which involve I'm sorry to say at Tesla, where Musk's former divorce lawyer was the general counsel for the company, and then people he'd been in deals with and so forth. So there was no they were independent because there was no business relationship between the company and that director.
Between the company, but not between Musk and all of his other...
Exactly. And there's a developing and rich, set of case law. Well, really nothing in statute, I don't think. That's about to change. About sort of what we mean when we refer to someone as being independent for purposes of Delaware. Okay.
Exactly. And I don't get me wrong, Delaware still requires fairly robust connections. And I mean, when I explain to my students what counts as independent, how close you can be and still be independent, my students are always shocked. I mean, it is very counterintuitive. So Delaware won't say you're not independent just because you travel in the same circles or anything. But there really has been this appetite for saying thick social networks can compromise independence. But that didn't used to be the case. This is relatively new. It's all in the last 10 years or so. So the bill changes that. The bill says if you're a publicly traded company, if you've designated certain directors as independent under the exchange rules, like the New York Stock Exchange rules, that person is presumed independent. And
Oh,
then
come on.
shareholders have to make have to meet this extremely high bar, even higher than now, to show that they're not. They can rebut it.
So Delaware is basically adopting the
adopting
NYSE and the NASDAQ definition of
And
independent.
your reaction was, oh, come on. Why was your reaction, oh, come on?
Because those standards are pretty weak.
They're very weak. They're so weak that ISS and Glass Lewis, they won't even use them. They they have their own measure of independence because they're extremely weak. So that's one change. The next change has to do with the procedures for cleansing. Let's say we're not talking about a controlling stockholder. This is not a controlling stockholder situation. It's a conflict with one director or several directors even. Under current standards, if you want to cleanse that at the board level, you need the body that makes the decision to be majority independent, meaning if the whole board votes, the board has to have a majority of unconflicted directors, or if you delegate the decision to a committee, the committee has to be a majority of unconflicted directors. But that's not what the new standards say. The new standards say if it's decided by the full board or a committee, all you need is for a majority of the unconflicted directors to vote in favor. Now, that sounds like a minor change, but it's really dramatic, and I'm going to explain why. Let's say you have a board of 5 directors, okay, and 4 of them are conflicted in some way on this transaction, but one of them is nominally independent.
And this is under this new definition of independence too. So that's okay.
We're already there's the new definition of independence. But let's take existing law. If there's a board of 5 directors under existing law and 4 of them are conflicted in some way, and one of them is nominally independent, under current law, if everyone on that board votes in favor of a transaction, that's not good enough because the board itself was majority conflicted.
Right.
But under the new standards, we would ignore the conflicted members entirely. We would only look at the votes of the unconflicted directors, the one guy. And we'd ask, did a majority of the unconflicted directors vote in favor? And a majority of 1 is 1. Right. So therefore, yes.
Could that? If that, in your stylized example here, if that one person voted against,
then it would not be cleansed. So what you'd have to, so the only way you imagine this working was you would you would have to imagine a world in which a board that's majority conflicted, maybe one unconflicted director, and everyone's looking at him and they're all deliberating together and they're staring at him and they're going, "So are you in favor?" And that you have to imagine.
And I've been that person. You know.
Yeah. Well, and there are people who will stand up, absolutely, but it. He doesn't have to form a separate committee. He doesn't have to have his own advisors, nothing. So there's a huge change from a 5-member board that is 4 people who are interested or dependent.
Right.
Cannot cleanse all but without forming a committee. They can't cleanse under existing law, and they'd be able to do it this way because one guy. I mean, think of how this gets litigated. All of these board votes, they're always unanimous anyway. So if you imagine a litigation situation, the board, to show something's cleansed, all they have to do is literally just identify one member who turns out to be unconflicted, and that's it. The case is over. So, that's what happens if you don't have a controlling shareholder.
Right.
If you do have a controlling shareholder who's conflicted, then the statute draws a distinction between take privates and everything else. If it's not a take private, then under the new standards, you can cleanse either with a committee that's majority independent or with a vote of the disinterested.
Oh, not both.
Not both. So that's already
which currently is that's what current law requires is both.
Current law would require both, and current law would say that their board committee can't even be majority independent; it has to be completely independent.
Right.
So this
that's what we talked about
levels.
with Tesla's.
Outside of the take on 2 levels. Outside the take private context, you only need one, and the committee and the board committee can be majority and not completely independent. And then under the bill for take privates, then you need both mechanisms.
Okay.
A committee that's majority independent, not completely independent, and a disinterested shareholder vote. But there's even more.
Right, and there's not that many. I mean, take privates aren't that. I mean, there's so many problems. So many of the
meaning an affiliate of the controller is taking the company private. But there's right now.
Go ahead.
There's more. The bill goes even further by limiting who even counts as a controlling shareholder, so that they're subject to this slightly higher bar.
Okay.
Right now, the controlling shareholder rule is, first of all, if you have more than 50% of the vote, you're a controlling shareholder.
Yeah, just automatically. Right.
Automatically. That's easy. And that's still going to be true under the new statute. But under existing law, you might still be considered a controlling shareholder if you have less than 50%, like Elon Musk with 20%
With
in
his
Tesla.
comp, right.
If the
He had
plaintiff-
under 20% at the time.
He had about 22% at the time. But basically, it's if the plaintiff can show that you, as a practical matter, exercise control over the board. So under existing law, it's either 50% of the vote, or the plaintiff shows that there was control exercised over the board. But
based on the facts and so
right,
forth.
Based on all facts and circumstances, exactly.
Okay.
But under this bill, there's a hard rule. No one can be a controlling shareholder at all unless they at least have 1/3 of the votes.
Oh,
now,
so there's a bright line kind of like standard.
Rule. Now, that is a hole you can drive a truck through, and the reason is shareholder agreements. Last year, we talked about this. Delaware passed this law that authorizes companies to adopt shareholder agreements that can allow individual shareholders to contractually exercise control over the boards. They can reject mergers, they can reject poison pills, they can approve budgets, all that kind of thing.
And that's all in statute now. That's all up.
Right, and that's in the statute. So under the new definition of a controlling shareholder, no matter how much power you exercise by contract, we don't care if you have less than 1/3 of the formal voting power. You're not a controlling shareholder, and your deals aren't subject to the higher cleansing standards. You can be cleansed with just straight up one director out of 20 happens to be disinterested and independent. And did they vote in favor? We're done.
Okay, so there's 3 or 4 different very significant aspects.
And we're not even done.
Of this. Okay, keep going, then we'll take a break.
Books and records.
Books and records. That's not even controlled. But let's talk about books and records for a second.
Okay,
go ahead.
So you request books and records all the time as an activist, right? Okay,
yes,
so
I do.
shareholders can get access to internal corporate records if they have a proper purpose. Board materials, board minutes, that kind of thing. Under existing law, if a shareholder has a need, which is usually because they're investigating some kind of malfeasance,
or they're contemplating some sort of a proxy or contemplating action in an annual meeting. I mean, that's a shareholder meeting. That's another good proper purpose. I know that.
Oh, that's absolutely good. And to value your shares, that kind of thing. But in particular, when shareholders are trying to investigate malfeasance, they can get informal materials. They aren't limited to formal board materials. They can get emails, texts, whatever else. If they make a showing,
communication stuff, but other internal books and records that aren't entered into the minutes of a board meeting.
Aren't these formal board materials? Usually they have to show that they exist and they're going to be relevant, that kind of thing. So in the past, shareholders have really gotten full-blown discovery about corporate wrongdoing, like Walmart's involvement in illegally distributing opioids, Facebook violating an FTC consent decree about user privacy, all that kind of stuff. And this bill would change that too. Shareholders would be limited only to formal board materials and nothing else. And I'm leaving out a lot of details, by the way. Like, even with all that, I'm leaving
we'll have to talk about this in another show.
Sure, in a future. Right? Yeah, exactly. But I want to be clear that every detail I'm leaving out goes in one direction, making it harder for shareholders to challenge management. The whole statute, I mean, it reads like a checklist of a wish list.
Wish list of what defense attorneys would want.
They just snuck in every possible change they could, big and small, to make it impossible, really, for shareholders to bring fiduciary claims.
All right. So there's the 2 parts of this. There's this whole, I can't remember, it's section 144. I looked it up at some point of the statute.
It's amending section 144, which right now has virtually no role in litigation, but now they're dramatically expanding
it. And that's all around what we mean by a controller and the process companies have to go through, and then amendments. And it sounds like the changes to the books and records, they're strictly, I suppose we could say, bad for activists, or whatever. But it sounds like the 220 stuff's a little simpler than the 144 stuff. And the 220 stuff basically just narrows statutorily the list of things that a shareholder can demand, and just says, sorry.
Yeah. I mean, and then sort of lists the bar for what you have to show. But
all right. So. One quick question, and then we'll take a break. What's the expected impact on the proximate cause of this, which was the Tornetta case? Which was
So here's the crazy thing. Tornetta is currently on appeal to the Delaware Supreme Court, and I don't know if this bill affects it. So here's the thing. Delaware has a sort of default statute that says any new law that it passes on these kinds of things isn't retroactive. It shouldn't apply to pending cases. So you'd think it wouldn't apply to appeal. But Every other time Delaware has amended its law, the legislature included a little note that explicitly said the law would only apply to new cases and not old ones. This time, there's no note. And defense attorneys have already been publicly arguing that the new law, which hasn't even been passed yet, should be deemed to apply to pending cases. So if this new statute applies to Elon Musk's appeal of his pay package ruling,
Oh my God.
he has a much better shot at winning. Not a slam dunk, but he has a better shot. And, of course, the new statute would apply to all those cases that were filed against him just before Tesla reincorporated into
There's like a dozen
Yeah.
new cases that
No,
were, or not.
but yeah, that it would if it applies currently. And again, like usually these laws, they say, will not apply to any cases that were pending, but it doesn't say that this time. Plus, there's also a question of what even counts as a retroactive application. So, for example, Paramount. Paramount has dual class stock, and it has this controlling shareholder, Sherry Redstone. And the company signed this merger agreement. They're going to be bought out by Skydance. Redstone gets cash for her shares, but all the public shareholders, they get kind of a mix of cash and stock. Now, this merger hasn't happened yet. There's only the agreement. And the public shareholders filed a lawsuit. They said there's a conflict here. Sherry Redstone is hoovering up excess payments for herself, and the public shareholders aren't getting a fair price. And they also complain because they think that she iced out another bidder who would have been paid more. So under existing law, this is absolutely a deal that would be examined for entire fairness, because Sherry Redstone signed a deal that gives her excess consideration over the minority. But if the new standards apply, she's very possibly immune from suit. That's because it's not a take private, and all transactions involving a conflicted controller other than take privates only need approval by an independent committee at the board level. Here there was board committee approval. So if that committee was majority independent, the whole deal is cleansed. And if the merger doesn't even occur until after the statute passes, then you can say it's not retroactive. So even though there's a complaint that's currently pending. And there's no question that the Delaware legislature understands this, because they keep getting asked in interviews whether the statute applies retroactively. But sometimes they say, no, it doesn't. And sometimes they're cagier. Well, it applies as soon as the governor signs the bill. But they still haven't added that language about it not applying
that little disclaimer, that little...
So they know that this is an issue. So it feels like they're passing the buck, and they know they're passing the buck, and they're still passing the buck anyway.
All right. Well, let's pass the buck to the break, because we've really, this is great. I mean, there's so much to talk about here, but we'll do that and then come back to talk about how this affects various players here, and then maybe discuss a little bit about the broader implications in terms of that power dynamic that we kind of hinted at. So let's do that, and we'll be back shortly here at Shareholder Primacy.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin. So, Mike, you are an activist. How will these changes affect you?
That's a big, interesting question. And I'm going to answer that in a moment after I talk through a couple of other kind of open questions, which kind of gets to the thing we started talking about a little while ago, which was the number of corporations and the data on this problem. It's pretty clear that a handful of companies leaving Delaware is enough to worry the legislature, but it's probably not going to decrease franchise fee income. Dramatically.
I think they're afraid it's more than. I think they're afraid that this trickle will become, ultimately
like a torrent.
Yeah.
Well, so I looked at some data at some point. Delaware incorporates tens of thousands of entities in a year.
Yeah.
And even more. Here we're talking about entities. Then we can talk about. And most of the entities that are going to incorporate are like LLCs and LPs and so forth. Mm-hmm. They're not corporations.
Yep.
Okay. And an even smaller percentage of those are public corporations. So we're talking about even though Delaware dominates the public corporate, relative to other states, we're still talking about we're still talking about a somewhat smaller percentage of the of a portfolio in a sense, because and that sort of reminds us that this might be a little bit of an overblown reaction to to sort of like what they sense. And again, we can talk about this data at some point.
Yeah. Actually, Andrew Burstein at UCLA just came out with a study, and I think he's finding that the fastest growing states for new incorporations aren't Delaware, and these are private companies. They're actually California and Florida. California,
yeah.
It surprises me. I mean, I get the tech sector's there, but their corporation law is not what I would have thought people wanted.
And the one thing I want to mention, though, is that in any given portfolio, there is a very small percentage of controlled public corporations. Okay.
No.
I mean, right. So sort of overall.
Yeah.
And that's actually worth noting, is that any smart activist that's planning or looking or constructing a portfolio tends to avoid controlled corporations. Right. Mm-hmm. Okay, and again, I understand the definition of control is starting to shift.
Yeah.
All right. Based on this, but overall, most shrewd activists are not going to be putting at least a big allocation into a company. There's got to be some really good reason. Mm-hmm. Okay, and there's plenty of people that kind of like Tesla and so forth, and that's kind of controlled. But again, that was that wasn't controlled under the it's not 50% owned by Musk. But so overall, we tend to try to find companies where like the entire insider ownership is going to be like comfortably under 10%.
Okay.
Even in the very big companies, it's under 5%. There's some small caps we look at and so forth, where you get insider ownership that's under 20. That starts to get to a 20. But even then, we're not getting to much of a control position, or worrying much about control here.
Okay.
Okay. So the idea that the definition of control is going to change is enough to be concerning. Mm-hmm. And especially connected to the redefinition of what independence means. Okay, because both those together would concern me and concern others I've talked to. Though again, there's not enough quite known, about how that's how it will affect specific companies, specific transactions, and so forth. Yet again, it's only been a couple weeks, but those two aspects of this kind of together, overlaid on the idea that the idea that the definition of independence is going to sort of revert back to the or go to the exchange definition, which is basically useless. Yeah. But that's something that activists are kind of used to anyway. Yeah. Okay, we just sort of accept that most so-called independent directors are not really going to be practically independent. So maybe we're just cynical that way.
Yeah, no, I think that definitely the company designated ones. I mean, that's why assistant class 2s don't use it. Although one thing that you had been saying actually before we started recording that I think is interesting is the way the statute is worded. It's so broad that normally, if a company adopts a takeover defense, like an advance notice bylaw, that kind of thing,
right.
That might get a sort of higher scrutiny and get enjoined. But I wonder if these cleansing standards could even translate to challenges to bylaws, because
to all sorts of other. That was the thing I was going to say.
And if they clear it, then it is. So I honestly don't know whether this statute could be read to even make it harder to challenge takeover defenses by treating the independent directors.
And that's the interesting thing is that
they adopt. Yeah.
Most activists, frequently will have in mind some sort of M&A deal, and there's all this news about M&A activism increasing and so forth. But go step by step. One of the first things is we need to get some sort of influence, maybe get a board seat or 2 or 10. And then get through the advanced notice. So there's a lot of intermediate steps before we get to a deal. Mm-hmm. Okay, and I think some of the perception, and this is probably wrong, some of the perception is that SB 21 is sort of trying to focus on protecting deals from litigation.
That's true. Like, so by the time you got to the deal stage, you would be much more influenced. You would be much more safe from litigation.
Right, exactly. And so, but if the and I think there's when I was looking at the statute, which I don't know exactly what I'm reading, there was something about transactions and acts or something.
Yeah,
like
that's
that.
why like the cleansing standards, so that you essentially they can't be the subject of judicial action. Apply to acts and transactions, and that's why I'm wondering whether act could.
And acts, if acts start to get to a lot of the more routine stuff, that activists kind of work on and think about, short of like some sort of a final transaction, takeover, tender offer, whatever, that would be much more concerning. I would say. So there's it's still. Because of the way the activists kind of think about and structure and make investments, it's not as concerning at the moment as to portfolio managers it might be to like a plaintiff's attorney these days. But there's clearly intention to possibly extend it that direction, and then it would be I'd be really really worried. Let's talk a little bit about the books and records part of this.
Oh yeah.
Which is the other kind of half. And I do them all the time and so on and so forth. It's worth kind of mentioning that there's sort of two kinds of books and records demands, I suppose. There's the stuff that litigation anticipates, where it's mostly kind of expected that you're going to do some sort of books and records demand in order to prepare for like a shareholder derivative suit or something like that. It's sort of like pre-discovery, I guess you could call it. Yeah,
that's exactly right. Yeah, you're supposed to.
And the limitations in the SB 21 are clearly squarely aimed at trying to prevent that, trying to really clamp down on that. Okay, the other half, the other kind of books and records stuff, is the stuff that I do a lot more routinely, which is first looking for shareholder information, shareholder lists, and that's really routine. And fortunately, based on my look at SB 21, that's probably not going to be limited here. But then there's an intermediate. There's all sorts of other stuff that I'm kind of looking for if I do a books and records demand. Okay, I'm looking for board materials, which I think are still going to be
they're still
allowed. And again, that's not stuff that's public. So it's worth trying to get.
Formal materials that are like formally part of the meeting.
Right, and it could be not just like minutes, which tend to be pretty nothing, but like board presentations, compensation consultant reports and all that kind of stuff. Okay, but then there's other things. There's like analysis of a merger that was done, or other. There's all sorts of other things that get discussed or don't necessarily make it to the board that we can try to request. Okay. And then we get into this really big battle or medium battle.
Those would be essentially, as I understand, if they didn't make it to the board, they would be largely
that's the problem. Is that and you got to really craft a proper purpose around that and so forth, and that becomes hard. And my sense is that stuff has become a little harder.
Yeah, and it's
potentially a lot harder.
This statute would make it largely off limits, as far as I can tell. I mean, if it's not a formal board, if it didn't go to the board, if it's not a formal material,
right. And the other worry,
even if they got it privately in email, if it wasn't part of the formal board meeting,
exactly. And the other worry is that board materials will become even less useful.
Yeah, because everyone they know they're completely safe.
Right.
If
you don't direct anything to the board, I don't know how you can make decisions or whatever, but so it'll be and again. When I'm doing this in an activist situation, if I'm trying to like nominate directors or something, I'm not going to litigate. There's no discovery process that's going to follow this. This is my one shot to maybe learn some information as a shareholder. So 220 is also somewhat concerning here, for this reason, because there's all sorts of other really interesting information that I'll try to look for that somehow is probably not going to be available to us. And the communications and stuff, and I mean that's all nice, that's all great, we love it, but we're so used to activists are so used to just getting pushed around and not getting some of this, and just relying on public records or that that's why we go talk to retired executives or competitors when we're trying to build a case. So yeah, there's one reaction, and again, we can delve into this into more. There's other parties, this isn't going to really affect, shareholders really routinely. ESG activists probably aren't going to notice this. This is really, it gets to some fundamental, disputes and rights, and we talked about, the power dynamic between, companies and their investors, and minority investors, majority investors, and so that's the other thing I was going to ask you about is let's talk a little bit about some of the larger implications here, and that's part of your job is not only to think about the nuances of law but the broad strokes. So what are your views? I have some of my own, but I'm curious what yours are.
Okay, well, the first thing, this isn't even the biggest picture, but there's one obvious implication, which is that the bill encourages moving corporate governance away from the board and into shareholder agreements, because shareholder agreements don't count as control for the purpose of under this 1/3 standard. So if you're a founder and you're going public and you want to maintain control and you have a choice, you can give yourself a majority vote with dual class shares, or give yourself
dual class shares
block,
and
or you can give yourself a solid block of dual class shares that keeps you just under 1/3, and then exercise control through a bunch of shareholder agreements. You're totally going to do that, because that way you avoid the higher scrutiny. So this really encourages people to use shareholder agreements over high vote shares, which really challenges what the corporate form even means. I mean, in academic speak, we'd say a defining characteristic of the corporate form, as opposed to a partnership or an LLC, is they're managed by a central board of directors chosen by the equity holders. So this statute really encourages a move away from that model, a move away from centering the board. So that's like a small thing.
That's worth just repeating for a second.
Yeah.
that there's, at least for newly public companies, and there's probably going to be some companies, controlled companies. I mean, you probably need to be controlled or controlled enough.
But where these VC-backed, those kinds of startups, they're going to have a choice, and they're very likely to want insider control. And now they know they can avoid the controller labor entirely as long as they exercise that control through contracts.
So you could exert that control through a well-crafted shareholder agreement and dispense with a dual class shares and a staggered board.
Yeah, and you're encouraged to do that. You're encouraged to do that, because if you don't have the dual class, or if you only keep you could even have dual class shares. You just have to keep the vote under 1/3. You are categorically not a controlling shareholder, and categorically any of your conflicted transactions are not subject to the higher standards.
Wow, I can't. Are there going to be shareholders who are going to? I guess they will. I guess if there's a hot enough stock that they really want, they'll.
So,
they'll agree to this.
But from the biggest picture thing, I think these amendments are really going to devastate shareholder litigation, or at least litigation over conflicted transactions, which is kind of the bread and butter of Delaware fiduciary law. So taken collectively, they're going to kill a lot, almost all merger litigation, all these compensation litigation, all those kinds of, buying your own company, buying your related company, all that kind of thing they're going to kill. They're probably also going to kill most Caremark litigation, the claims that the board...
about board negligence and so forth.
Board violating their duty to the law, duty to comply with the law. So those are the claims where you allege the board intentionally violated the law, something like that. Because between the independent standards and the lack of books and records, shareholders aren't going to be able to make the case. We might still see claims over takeover defenses. Maybe we'll see, because I'm not sure how the statute applies to those. Maybe we'll see some contractual claims, like the scope of the shareholder agreement. And you might have a really egregious scandal every now and then that, the Wall Street Journal gives you the information needed about what went on in the board. But for the most part, I don't see fiduciary litigation having much of a future.
This is interesting. So Delaware is trying to protect its franchise fees. I mean, that's one way of looking at this.
Yes.
There's franchise tax or franchise fee income, and they're going to be relinquishing all the economics of the litigation.
Exactly, because I think Delaware depends on more than just its franchise fees to maintain its status. It needs the case law, and I think it's going to kill the case law. But now, to be fair, the statute has a lot of defenders who would dispute my characterization. They all say these are
the proposed bill.
Yes, okay. All the defenders are going. They say these are balanced amendments. They balance all the interests. They restore the balance. It's a balanced approach. Raymond Shaw is the kindest, bravest, warmest one. They just keep using that word balance It's very obvious that the memo went out, that
Right.
balance is the word to describe these amendments, and I really cannot express how true that is not. These amendments,
Right.
they're really
Or
extreme,
false.
and I want to explain why in a sort of big, like broader picture. So
Go ahead.
until now, Delaware was defined by the idea that it was all based on judicial decisions. That's where their corporate law was. It
Right,
was
not statute.
Not statute.
Stop right there.
Yeah.
Because the legislature writing the statutes was fairly not present and pretty passive when they
And like they would put like these ground rules, but this concept of fiduciary duties and the obligations that boards owe, that was all common law. That was all the case law.
Right.
So almost all of the corporate law, the bread and butter of corporate law, was all developed case by case based on the particular facts before the court in a particular case. And I got to tell you, like decades of articles have been written about how this is definitional for Delaware. Corporate law is made by judges considering specific facts of particular transactions. And this statute gets rid of all that as far as it possibly can. It replaces judicial lawmaking with a statutory set of standards. Now, I personally don't have a very strong opinion about whether it's better in some absolute sense to create corporate law by statute or by case law. But until now, Delaware had a very strong opinion that case law is better. And this legislation is just this astonishing rejection of that theory. It's a direct rebuke to the Delaware courts, but it also abandons everything that Delaware previously claimed was special about Delaware. So that's one big theme.
Okay.
But the other thing that's really striking is one hallmark of Delaware law was, I mean, if a state can have an attitude, Delaware had an attitude.
Right.
It had an attitude, and the attitude was arrogance. Delaware was arrogant about its corporate law expertise. You could see this in the judicial opinions. There's this general disdain for the idea that any other jurisdiction knows anything else about corporate law. I always thought this was really funny, that you'd read these opinions and they take offense at the mere idea that another state would have the temerity to enact their own corporate law.
Everybody adopts ours. They refer to ours anyway, so we might as well just...
Exactly. Why would you even bother having your own corporate law? Why can't you just leave it to Delaware? But this statute explicitly incorporates by reference the federal stock exchange standard. It even borrows language from the Model Business Corporation Act, which is this generic off-the-rack corporate code that the ABA drafted. And I don't know what word to use to describe this, except it's embarrassing. It's Delaware relinquishing the idea that it has some special claim to develop corporate law. I mean, I can't convey what a revolution in attitude that is. So, and when I think about it, I keep coming back to these new standards for independence, where you're presumed independent if you're designated as such by the stock exchange. So we know that.
I'm going to repeat.
Yeah.
That's bad.
Yes. That's
no one
bad.
likes that.
Nobody likes that. But here's what grabs me. It's not just that the exchange rules are lax. Fine, they're lax, but that's not actually what kills me about it. Until this bill, I would have told my students that in Delaware, independence means something different than what the exchanges mean. Like definitionally, it means something different. Because the Exchange Act standards of independence, they're based on like a general free-floating kind of concept of independence from the company. That's what is being assessed. Is the director independent from the company in general? But in Delaware, previously, you can't examine independence in the abstract. Under Delaware standards, the old Delaware standards, you didn't ask, are they independent in some general sense? The question was, are they independent for the purpose of approving one particular deal? And maybe they were for one deal, and maybe they weren't for another deal. In one case, the Delaware Supreme Court said that a board member might be independent for the purpose of approving a contract and not for the purpose of deciding whether to bring a lawsuit. So Delaware's concept of independence has always been very contextual. And that matters because when it comes up in litigation, we're asking, are you independent for this particular purpose?
Litigation's about the facts of a case.
Exactly. But when you import the Exchange Act standards, they're not just weaker, they're orthogonal. I mean, they're not the question before the court. You're requiring the court to answer this completely different question than the one that's actually in the case, which is not independence in some broad strokes way, independent for this purpose. So by relying on these Exchange Act standards, they actually make the law incoherent because now judges have to consider this sideways issue that just isn't what the case is asking. So what does that tell me? Well, what the statute is saying is, if the statute could speak, it would say,
the bill.
Delaware law has no value.
Right, they're kind of giving up. I mean, based on what I'm saying is that there's this kind of vague threat
Yeah.
being leveled at the legislature.
And they're
And the
tossing it
legislature's
out.
basically saying, okay, well, sure, we're going to sort of
Get rid of
relinquish
everything.
100 plus years of carefully crafted process and standards here.
Exactly. Delaware law
because-
has no value. That's what
Yeah.
they're saying. And there's just not a whole lot of value in all of this stuff. Exactly. As you say, as the judges have developed. And there's not even a whole lot of value in the law itself as a coherent project. It's a rejection of the value of any law in this space to police compliance.
This is what I was thinking about when I said, I wonder what a law professor thinks.
Yeah, it just like that incoherentness of the Exchange Act standards really just encapsulate this idea that it doesn't even matter if the law is coherent because the law doesn't matter. So why would the statute do that? Well, one reason, if you anthropomorphize the statute, I'm sorry, I get vibes from the statute. If you anthropomorphize the statute doesn't just see a whole lot of benefit to having shareholders impose procedural safeguards on conflicted transactions. The subtext is corporate insiders do not need to be constrained by formal procedures. Formal procedures do not really protect shareholders in any meaningful way. They just impose some kind of tax on the company.
Right, it's
and therefore we should
just
get rid of
transaction
formalities.
costs that we need
Exactly.
to, right, okay.
And I really want to be clear, that's actually not crazy. It's not even outside the mainstream. I mean, it's a very common attitude that shareholder litigation doesn't really benefit shareholders. I mean, you've heard this a million times. It's all just nuisance lawsuits.
Just trying to
Yeah.
line the pockets of plaintiffs' lawyers.
Exactly. It's an argument you hear all the time that shareholder litigation doesn't accomplish anything. But that wasn't Delaware's view until now, apparently.
Right.
And there's another message, though, and that's the law has no value in this space because corporate managers will not be constrained. They will not be limited by legal rules. If you try to constrain them, they're going to pick up and move their companies elsewhere. They can't be limited by law, so therefore there's no value in Delaware even making the attempt. And that idea that procedures have no value, that they only stand in the way of what a singular leader wants to accomplish, that people who hold positions of great power can't and shouldn't be constrained by law, I look around and I think
that's symbolically very, very
that's kind of the mood
concerning.
of the moment, right?
Yeah, right?
I mean, it's the broader theme of the time we're living in that we should just clear space for strong leaders to take action, and legal technicalities and formal procedures are kind of useless impediments. So I feel like what's happening in Delaware is this microcosm of what we're seeing play out on the national stage. I mean, even the way the bill was proposed, bypassing the usual process.
Right, and evidently one of the drafters was a big firm that has done a lot of business with Tesla.
Yeah, I mean, now to be fair, like Tesla's done, like, Tesla has like a zillion, like throw a stick and you'll hit 10 Tesla attorneys, and also that's a really big Delaware firm, but the optics of it are not great.
Right, yes. So, wow. There's a lot of themes here about the shift in power.
I keep looking at this and I feel like this is like the miniature of what we're seeing more broadly.
It's very, very, very illustrative of some broader themes, like I guess in civic life, which is, concerning and interesting, but then also, you have to reflect back onto how it's going to affect. Well, again, and I always like to think about it this way. Who are the parties to this? And there's a bunch of plaintiffs firms, a bunch of defense firms in Delaware that are clearly interested in this. My understanding is, I guess there's some unions that are finally getting involved in the litigation, in the legislation.
Union interests are really interesting, and I'll just say why for two reasons. So one, they're going to say it's because we're stockholders, like our pension funds are invested, and we think that this takes away procedures that protect shareholders. That's what they're going to say. However, in general, unions tend to like corporate governance procedures that put, I call it friction in the boardroom. They like laying procedures that control how managers conduct business. And I always got the sense that in part that's because as unions, they're sort of suspicious of unfettered insider control, even apart from their interests as stockholders.
I think that's right.
So I think they dislike this bill. I mean, they're going to say they dislike it because it doesn't protect minority shareholders. But I think part of the mood is they dislike it because they don't like seeing corporate managers just be able to act completely without any constraints at all.
Right. Well, this is, we have to start, we got to start wrapping up. We've taken so much time here, and we need to spend more time on this, and we will do that. I commit to the followers here, we will do that. Yeah. But Senate Bill 21 is now pending.
Yeah.
My understanding is that there's possibly some sort of expedited treatment of it.
Yeah, there's going to be hearings next week, and then Yeah, I mean, they want to get it passed before proxy season, so.
Right, they're not going to wait till end of summer, which my understanding is how Delaware law works.
That would be normal. They're not doing
right.
normal.
Yeah, right. So they're not doing normal here. There's lots to delve in, and we should probably do that. We could probably spend a whole show talking about some of the controller aspect of this, some more talking about 220 and so forth, and probably just a follow up after this develops in the legislature.
Especially if they make changes, which I don't see that. I don't know that that's likely, but could happen.
I don't know. We'll see. The union, Delaware is a very strong union state, and there's a non-zero chance that the union interest might exert a little bit of influence here, but who knows? Anyway, all right. We got to, like I said, we got to wrap this up. We've taken way too much time here, though. Not bad time. So it's great talking about all this, and we will continue with this subject, I'm sure. So there's more on the way. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is the Michael M. Fleischman Professor in Business Law and Entrepreneurship at Tulane Law School and an affiliate of Tulane's Murphy Institute. You can find me, Mike, at theactivistinvestor.com and Ann at law.tulane.edu. Our podcast is produced and distributed by Free Float Media. Thanks for listening, and we will cover all this again sometime soon.